Weekend Report, I'm Masachaba Mposwa. Human rights groups this week held a joint media briefing to outline their plans to have an inquiry launched into the National Prosecuting Authority's handling of the Omotoso and co-accused trial. The bodies, including SA Human Rights Council, CRL and the Commission of Gender Equality, made remarks on issues within the justice system that led to failed prosecutions. They resolved to institute an inquiry into the processes that led to the outcomes of this case. So, what available resources do these institutions have going forward, and would a private prosecution be a feasible option without a possibility of a retrial? Legal analyst Melusi Xulu tells us more. Good morning, Melusi. Welcome to Newzroom Afrika.
Good morning, Ms. Chaba, and to the viewers at home.
All right, let's start with this one now. What are Chapter 9 institutions in South Africa? What role do they play in the country's democratic landscape?
Well, they play a role to look after the rights of the citizen. For example, South African human rights, we've seen them when, there will be people who will be making racist comments. They will then be called and there'll be a case opened against them in that regard. And also, I believe it's the one for cultural, religious, and linguistics. That organization looks at how the churches abuse the rights of the congregates in that regard. And then also for gender equality, the commission is looking at the violences that are done to the different genders. So I think they are appropriate for this case to look at the issues that might have happened, but then we'll see whether the options that are there will be enough to assist the victims in this case.
What are your thoughts on the acquittal of Timothy Omotoso and its implications for the justice system's handling of sexual assault cases?
All right. If I'll speak as a father and as a citizen of the country, I think it was not a good thing, to see such a case that has that is a high-profile case where it looks as if there were some mistakes that were done. Because when it comes to gender-based violence, our stats are very high. If you go and look at the stats, you'll see that gender-based violence crimes are very high. And I remember last year, towards the end of the day, it was so high, it was reported. So it doesn't look like a good thing, Ms. Chaba. But at the same time, I think let's investigate thoroughly what really happened. It's better. I think it's better that the approach that the NPA is taking. That's the approach that I appreciate. Because the NPA has said, look, we've noted Judge Kuman's comments that the prosecution's handling of the case was not proper and the cross-examination of the accused was not done thoroughly. But what they will do is they will study the judgment. They will look at the records and then they will read the records and then they'll make a determination. I think that's the better approach because it will give us more information what went wrong. But at the same time, I understand what Judge Kuman was saying, that she cannot assist the case of the state when the case is not strong enough. She has to do justice and acquit the accused. It's unfortunate that that had to happen. But if the prosecution and the police do not do their job, I think it does not look good for the fight against gender-based violence crimes.
Now, when you say that the cross-examination was perhaps not done thoroughly, from your legal perspective, what should have been done? What could have been done better?
All right. Let us explain first to the viewer what a cross-examination is. Cross-examination is basically where if the accused is going to be on a stand and he has testified, what they call evidence in chief, then he will be cross-examined by the prosecution. What they need to do is to show that what he has stated on the witness doc is not the truth, and they must discredit his testimony. So Omotoso and his co-accused, they testified for the whole day, and then the prosecution had 9 days to cross-examine Omotoso and the co-accused. Now let us remember that the charges are 32 charges, so the complaint of the judge is that the cross-examination was not beyond 11 a.m. or 12 p.m. So it shows that they did not give themselves enough time. But Ms. Chaba, if you look at the records or you just read the reports, you study further and you can see where the problem began. If you give me a second. I believe 4 prosecutors or 5 prosecutors were involved in the case. There was a prosecutor who started, he didn't continue, and then the other one, there was complaints by the witnesses that he was or she was not assisting them properly. Then the prosecutors who cross-examined, there were 2 of them, and then the one who closed the case or who argued was another one. So that shows that the strategy might not have been aligned properly. So I think that might have led to, the prosecution not doing its job properly. But like I said, let's wait for the NPA and hear what their report is, and maybe the inquiry that is stated by the Chapter 9 institutions will also assist. But let us remember, at the end of the day, the test of a criminal case is that the case must be proven beyond reasonable doubt. And if the judge does not find that it's proven beyond a reasonable doubt, there will be an acquittal.
In light of the outcomes of this case, what legal options are available to the victims in the Omotoso case following the acquittal?
Okay, the case was in High Court, so the next case or the next court will probably be the Supreme Court of Appeal in Bloemfontein, if they do get to be given a chance to appeal. Now, when you appeal, what happens is, Machaba, is that you're appealing and you're stating that the judge might have not made the right decision based on certain reasons that you state. So my challenge with this case, but I'll see what the NPA will say about it, is that it's not necessarily about the judge making a mistake when we look at it on the face of it. It's the judge saying the NPA made a mistake. Now, how will the NPA resolve that if it's proven that the prosecution and maybe the investigation was not done properly? Because there's nothing that will be appealing against, because you will not be appealing on the judge's decision, but it will actually be your internal problems as NPA. But however, it could be that the NPA might find something that they may say maybe the judge did not look at properly. But on the face of it, I don't think it looks that strong for an appeal. But let's hope for the benefits of the victims that something will happen. But like I said, at the end of the day, the case must be proven beyond doubt. And if there's no case, unfortunately, nothing can be done.
And with that said, and given the minister's investigation into the NPA's handling of this case, what will these findings assist with? Could they potentially lead to further legal action against Omotoso, or will the acquittal stand?
Look, if they can't find anything that the judge might have not done properly in terms of the judgment and for the purposes of appeal, I don't think there's anything that they can do. Maybe the inquiry will be more internal in terms of whether did the police investigate properly and did the prosecution maybe do its job properly. Maybe it will be an internal inquiry, but it's usually not something that we see in cases where a judge will complain about how shoddy, inverted commas, the prosecution's job was. So I think it will be an interesting angle to look at. And unfortunately, the victims of this case had to suffer, and they will not get justice if it happens that the allegations are true, that the prosecution was not doing a proper job.
What are your thoughts on the effectiveness of the National Strategic Plan on Gender-Based Violence and Femicide? What improvements would you suggest?
Okay, I think the first thing that I would suggest is, at the inception of an investigation, if there's a case that is open, I believe that the police must be properly trained to take statements and to make sure that what the victim is saying is properly done. In rape cases, we have what we call a first report. So a first report is where if a victim has been raped, they report to someone who's older, if it's a young victim, or someone else, even if it's an old victim, they report to someone and say, I was raped by so-and-so. So that statement is also important. The DNA as well, how it's taken, the chain evidence must be done. So the investigation stage must be more specialized. Well, there is a specialized department for that at the police, but I think they must do more and be more careful about how they take statement. The reason why I'm saying that, Mas Chava, if you check in this case, there was a complaint that what the victims were going to say in court was different to what was stated on the statements. So I think that's the first thing. And beyond that, I believe, we as the citizens must also be vigilant in the fight against GBV And we must be aware of the organizations that assist with us so that we can work with them in reporting cases and making sure that the cases are strong enough. But what I've seen as well, just for a second, is that the problem with GBV cases is that some of them, there's what you call a mediation, where you find that the victim will claim money for such a case, for such a case to be withdrawn. So at the end of the day, the case never goes anywhere because there will be some money that will be involved. Also in family situations, the breadwinner will be having a case open against him, and then later on it will be withdrawn. So I think there's that power dynamic that is involved when it comes to GBV.
Melusi, what are your thoughts on the rule of double jeopardy and the inability to go for retrial?
Look, I think at the end of the day, once a trial has been done and you find yourself as an accused where you've won the case, it's a little bit unfair. In fact, it's unfair that it's expected that you have to go through the same process again because you've won the case and you spent years defending yourself. So I think if we look at it in terms of justice, because remember, when you talk about justice, we have to note that we're talking about justice for the victim and for the victim's family, but we're also talking about justice for the accused. So at the same time, if the accused has, done the case and he won, it's not fair for him to start the case again. I think what may be something that may be looked at in the Omotoso case, if I'll just change a bit. I think maybe let's look at whether there are any other victims. If there are, maybe that's the best chance they can get to get justice. But at the end of the day, if an accused has been acquitted, let us give him that benefits of a doubt, because with the Constitution states specifically in Section 35 that everyone is innocent until proven guilty. So if you're not proven guilty, why should we now focus on trying to get you guilty at all costs? Now, that's not justice.
What role can Chapter 9 institutions such as the South African Human Rights Commission play in supporting the victims and promoting accountability in this case?
I think the best thing they can do is to, they have a legal team that can assist them to maybe for advice and so forth. But let us remember about the separation of powers, where there's the legislative, there's the execution, and the judiciary. So the institutions must respect independence. You are not expecting the Minister of Justice to, call the NPA into order so that she can state what she wants. Because if you read one of the statements that she makes when it comes to cases that are done by NPA, the minister has stated that she respects the independence of the judiciary and the authorities that are investigating. So it's important that they can play their role as per their constitution and their objectives, but they must not interfere with the other institutions' role as well.
All right. In closing, how can the police and prosecution improve their handling of gender-based violence cases to prevent similar acquittals in the future?
Yes. Okay. I'll look at it from a defense point of view, because I'm a defense attorney when it comes to criminal cases. What I've noted is that when it comes to GBV cases, they try to do their best. But like I said just now, I think the investigation must be done thoroughly and properly. Remember, sometimes you'll find that a person will be speaking in his home language, and then the statement will be done in English. Sometimes that initial process, you find that there are some things that will be left out and there are some things that will not be done properly. So you end up not having a properly investigated case. So I think they need to improve that part of taking down statements. I'm saying that because from experience, I always pick that up for my clients when I'm defending them. And you'll find that those will be one of the things that will assist in, winning the case. So for the accused. So I think the investigations must be done thoroughly. What we've seen in this case is that the police might have not done it properly, but also, just to end, if you are a prosecutor and you're cross-examining, you have to know what was stated by the accused. You have to know what your case strategy is. Now, in a case where you have 4 to 5 prosecutors involved, I wonder, and I think that will be a critical question for me, Ms. Chaba. I wonder whether the prosecutors who cross-examined, did they have the transcripts to see what was stated beyond the docket? Because they need, if you are a new prosecutor in a case that is partly heard, you need to know what was stated so that when you cross-examine, you can be able to find out the contradictions. I hope to find out whether they did have transcripts to be able to cross-examine. So I think people must just do their job to the best of their abilities to conclude.
All right, Melusi, thank you so much for your time.